It's money.
Oh, no, green. Who no go green? And then we go to free, but we no go green. Why them postpone now? Just for what they like now. And then postpone now, and I'm what's now. What's this glass?
But even one
Okay. No joy. See, why do you postpone now? How do you postpone now? You remember what they postponed? Revolution now!
Please tell them the court is still sitting.
The court is still in session.
Yes, now. Sir, can you have what transpired in court today? We came this morning for the hearing of our appeal against the judgment of the Federal High Court delivered by Justice Omoyele in 2019. We had hoped the appeal would be heard today because we had filed all our processes and served Leonard and INEC. Leonard has never appeared in the appeal. I've not seen him, but he has been represented consistently by his lawyers. So when we came on Tuesday, we were confronted with a notice of change of counsel by lawyers who are now representing Leonard. And I felt, well, every litigant has the right to determine who should represent him, to change his counsel. But as I indicated to the court, when you have a lawyer or a team of lawyers representing a litigant in a matter from 2019 consistently, and just at the peak of the case, when the matter is to be heard, the person says, I want to change my lawyer. The person says, I thought my lawyer had filed my brief. I was misled. I just realized they didn't file. And the person now briefs a new lawyer who comes into the matter and still doesn't file the brief, but only asks for permission to file. Whereas they could have just filed, as the learned justices of the Court of Appeal observed, and sought a deeming order to deem the appeal as properly filed. Which is why I said in open court that for us, this is a delay tactics. You would have observed at some point that my lords even made an observation that why didn't you file? You could have just filed this appeal and we would have just deemed it so that the appeal can be heard. But of course, we know what this is about, yes, right? It is just to buy time. But you know, the clock of justice may be slow, but eventually it will lead to a positive result. Yes. So today we have also, interestingly, even though the law says he's an unbiased umpire and he's not supposed to meddle in intra-party disputes, INEC is supposed to stay entirely neutral. But you members of the party, you are aware of the role INEC has played in this matter. Absolutely. And you know what it has been. So they have filed their brief, and we are happy they have even filed. Because in the position canvassed by INEC in their brief of argument, INEC agrees entirely with us, with ground one of our notice of appeal, by saying that they agree with the appellants, Mr. Sowore and Dr. Malcolm Fabi, that the Federal High Court did not have jurisdiction. And the law is that when a court lacks or is bereft of jurisdiction, every proceedings, decisions of that court that takes place without jurisdiction is a nullity. So what that implies is that INEC is also saying that because there was no jurisdiction, then they couldn't have been a valid judgment. But interestingly, INEC was assaulted by saying, yes, we agree with the appellant that the lower court did not have jurisdiction. However, you, the Court of Appeal, do not also have jurisdiction because the lower court didn't have jurisdiction, which we have responded to. I'm not going to comment on what the outcome would be, but all we are saying is that our judiciary, and I have made that observation in our reply, is based on hierarchy of courts. And that hierarchy under Section 7 is established for a reason. So that when you have the High Court give a decision, and the High Court under the Constitution is constituted by one judge, right?
Exactly.
And you are aggrieved, you now come before the three wise men of the Court of Appeal. The essence of having, as you would have observed, there were three justices who sat, so that three people can see what one person may have missed. And that is why even at the Supreme Court, you have 5 justices. So if the High Court was wrong to assume jurisdiction, as INEC themselves have said, it therefore means that the Court of Appeal has the duty to correct the wrong of the High Court. Exactly. So when we exercise our right of appeal, having been affected by that judgment, which INEC says was given without jurisdiction, and when Sowore has also activated his right of appeal and activated the appellate jurisdiction of the Court of Appeal, he's simply saying, let the error be corrected. So this is what is before the Court of Appeal, which eventually has to be determined. And when you look at what we have filed, we have responded to everything that they have said. I have also cited the proposed argument, brief of argument of Leonard, what he is saying in response to the appeal. And I find it interesting, but I'm not going to speak on that until the matter comes up for hearing. But when we respond, it will also be clear to the Court of Appeal who is right and who is wrong.
Yes, yes.
So for us, this is where we believe justice is going to be done to us in this matter.
Right.
Lastly, you would have observed that I did appeal to my lords at the Court of Appeal to be considerate and lenient with us in adjourning this matter, because this matter has protracted since 2019. It has had a very protracted history, and that was why I appealed to the panel to give us a shorter date. And luckily for us, because if you look at the docket of the Court of Appeal, you would have seen what happened. Lawyers are still filled. Some cases may not be taken today because the Court of Appeal has so many cases. So I had to appeal that because this is a political matter that revolves on the leadership of a political party, and because INEC has issued guidelines for the next election, that my lords should be lenient and give us a shorter date. And it was on that premise that we have been asked to return on the 4th of April 2022 for hearing. And we are grateful to the court because other cases